I have here or would like a copy of it so that folks don't have to take notes, just let me know, give me a card, and I'll send you an email with an attachment. Now, what impact does all this have on the standard of care? And the standard of care, of course, is the barometer, the limbo stick by which professional practice is measured. In order to advance a claim against a design professional, if an owner or a developer who engages the design professional believes that there's a deficiency in their performance, what they must demonstrate is that the design professional failed to satisfy the applicable standard of care. You fell below that reasonably prudent architect standard, and the way you do that, of course, is with experts. You hire an expert who says, yes, worst set of plans and specifications I've ever seen. Defendant hires an expert who says, no, that's the way it's done in the industry. It's exactly and precisely the way everybody does it. And then the jury tries to make sense of two people in the same profession saying exactly the opposite thing about the same collection of facts. One of the concerns with respect to sustainable design is in the AIA Code of Ethics, and there was an interesting statement here in a publication by Marsh a couple of years ago, and it was such requirements, meaning the contractual terms directing the architect to be mindful of these things, may have an impact on a legal standard of care, raising it above the traditional negligence standard that is covered by professional liability insurance. Sort of a warning shot across the bow. I am not aware of any instance anywhere in the country where a professional liability carrier has denied coverage because of this. This is one person slithering around on their belly, looking for that crevice, looking for a chink, looking for a claim, looking for a hook on which to hang a professional liability claim. And as I said, I am a little uncomfortable with what the AIA has done with that provision, that requirement, because it is so broad and it creates, I believe, a very difficult standard to achieve. Now, well, how about the LEED certification? We as design professionals have worked with our client, and now on their behalf, we submit the project, the plans and specifications for LEED certification. In doing that, are we, the design professional, creating some kind of a warranty that can come back and bite us in the fanny? Have we stepped too far out there on the limb because we are now advocating on our client's behalf that, yes, this building is entitled to silver certification or gold or platinum certification, and we're going to the lead agency now to procure that certification for the client? Can that rise to the level of a warranty? Are we agreeing that, yes, this is what we have done, but if it fails, can a claim be brought against us? Again, it hasn't been tested yet by the courts, but at least one professional liability carrier has said, I wonder if this is going to create an issue for us. I wonder if this too might compromise our professional liability coverage. Now, what if we fail to advocate for LEED certification? I thought this was kind of an interesting comment by someone who is a big advocate for green. And for those of you who can't read this, this is a quote from a keynote address at a green building from a green building consultant, an address at a gathering, and he said, quote, "What part of a 30% increase in the value from LEED certification is hard to communicate? You are doing your clients a disservice by letting them build projects without LEED certification. It almost amounts to dereliction of a design professional's duty." Wow. If we don't do it, are we breaching the standard? If we don't bring these neat concepts and neat ideas to our client, are we below that limbo stick? Have we fallen below the applicable standard of care? I would suggest to you, if you've entered into a 2007 AIA standard form agreement between owner and architect, you probably have. You missed it because you have an affirmative obligation under that contract to come forth to your client with suggestions about implementing some of these green design features. So although this is sort of an extreme statement, putting on my slithering around on the belly, well, that's where I live, so I don't know. I can very much appreciate this as a potential claim. What about green products? What are some of the problems that can come from green products? This is hardly a new concept. Design and construction is all about innovation. All LEED design and green construction is bringing in new products with maybe a different purpose. They come from a different source. It's recycled material. It's eco-friendly. but it's the same stuff. We're designing buildings today a whole lot differently from the way we were 30 years ago or 30 years before that. It is an evolving industry, and new products are out all the time. This is just a new and different and interesting feature, and I'll give you an example of something that both Kathy and I worked on, and it's almost worked out, but not quite. And it is exactly and precisely this issue. Those that do civil design worry about water management all the time. If you're doing the civil work on a school or a shopping center, you have to figure out what to do with all this water. You can't just slough it off somewhere. You have to store it. You've got to slough it off over time. You have to be able to contain it. And there are a host of traditional products that will help you with this. Corrugated metal underground piping, big concrete basins that you can put underground. Or there are some relatively new eco-friendly products that are out there. Well, I say eco-friendly. Some products made of a lot of aftermarket material. There is a company from that is headquartered overseas that markets a product that essentially holds open big holes in the ground. The product looks very much like egg crates, and they hold open holes under the ground where you can essentially store water. You have to put fabric around it and all that kind of stuff. It is a wonderful product in the sense that it's fairly inexpensive, it's durable, it can be constructed relatively quickly, and it's less expensive than the traditional molds, and it's made from aftermarket material. It's made from recycled plastics and so forth. It sounds wonderful. It sounds really wonderful. This system was employed on a school project in Virginia. It was covered under quite a bit of fill, but the manufacturer of this product and the local supplier of this product reviewed the engineer's design and said, yes, that's a good design, my product will work. The stuff was constructed, the fill was placed, within a week it collapsed. It collapsed. And it was a 3-ring circus, and here was the issue. The contractor said, you can't blame me, I built it in accordance with the plans and specifications. There's something called the Spearman Doctrine, which applies in all of the states, and it says essentially this: if a contractor follows the plans and specifications in accordance with his contract and builds it properly and it fails, the contractor's not liable. So that was the contractor's argument. I gave you what you called for. So the finger turned to the design professional. The design professional said, whoa, standard of care. I designed this in accordance with manufacturer's literature. I had the manufacturer bless my design. Take a look at this. Look at all my calculations. I have an adequate factor of safety. Everything was done just exactly right. I incorporated the manufacturer's details in my design. It's all right there. It's even got his logo on it. It can't be designed. In Virginia and in many other states, there are very strict privity requirements, meaning in situations like this, you can only sue a party with whom you have the contract. So we had the owner who had contracts with the architect and with the contractor. Down the contractor side, the contractor had a site work subcontractor who contracted with the supplier of the material, who had a contract with the manufacturer. The owner couldn't get to the manufacturer, the general contractor couldn't get to the manufacturer, and the manufacturer is overseas. So what did they say about the design professional? It wasn't enough. This is a quote from the expert report in that case. It isn't enough that you adopted and incorporated the design criteria provided to you by the manufacturer. This is a relatively new product. You should have done more due diligence. You should have looked under their petticoat. You should have found where these facilities had been designed and constructed before. You should have found out for yourself whether there was a track record. This is a relatively new product. How can you foist that on the taxpaying public at a public school without doing your due diligence on this project? Kind of scary. Kind of scary. And that became, it was a sort of a one side against the other, contractor lobbing mortar shells at the design team and so forth. But this was the key issue that the civil engineer had to face, that they didn't do enough due diligence. Hardly unique to green engineering.
This was an arbitration?
This was not an arbitration. This never went to litigation. A very creative solution was developed to try and get this fixed. Essentially, they changed the whole design, the whole civil design for the school, and came up with a less expensive water management alternative, and everyone contributed. Everyone contributed to some degree to get the thing done. It was a very thoughtful and creative thing, which is a disappointment because the lawyers, we would have fought for that. So the revenue we lost was terrible.
The firm was very concerned. It was dramatic.
It was
not an
millions
easy
of dollars in potential exposure, and it called out for a creative solution because there were so many thorny issues. Now that there, yes.
Did you solve it?
I was the one holding out for it not to solve. I hadn't earned my fee yet. No, we came up with what we thought was a very creative way, and the owner, there was some give from the owner. Everybody had skin in the game. We had delay issues. This school had to be delivered. You couldn't use it without the access to the site. So there was motivation from all corners, and I thought it was a very thoughtful resolution. Anything you can do to keep things out of court. I'm joking about fees and lawyers and all this.
You know,
litigation should be the last
Hobbie,
gasp attempt.
Just so that everybody does understand, this guy is fantastic, and there's no way that he would ever put on a slither suit and would not be part of a constructive solution. We know that from our own experience. So he is joking.
You know why they bury lawyers 12 feet deep?
Yeah, because deep down they're not all that bad.
I mentioned before why there is so little case law about green engineering and lead engineering, and it's because in the standard form industry contracts, there usually is a requirement that if you have a beef, if you have a dispute, you have to go to arbitration. That's changing now. The AIA is stepping away from it, and folks are using courts more and more as a means of dispute resolution, more and more instead of arbitration. But I think the more realistic solution is people have an appreciation of just how much it costs in time and money and, quite frankly, exhaustion of taking the matter in court. I'm not kidding when I say it should be the last of all possible alternatives. It's there if we need it. Everything else ought to be tried before people go to court. But there just aren't many cases out there, but there are a few. There's an interesting case that took place up in Maryland. It was filed up there not too long ago. It was Southern Builders against Shaw Development. It was a condominium project, supposed to be 23 luxury condominiums. The litigation was kicked off by the contractor filing a mechanics lien. Contractor wasn't paid the full amount of its contract fee, and it put a lien on the property. It attached the property for some $54,000 or $55,000. What did the owner do? In construction litigation, if you get sued, you sue back. If someone sues you to collect their money, you whop them with some huge claim. And that's what happened here. Back against the contractor was a claim for $1.3 million. And it was based on not delivering a LEED certified building. There were some interesting, it was all kind of reasons why the project was a mess, but what was alleged against the developer was this, or the developer alleged this against the contractor, and I'll quote it for those on the side. The project manual and scope of work require the contractor to construct an environmentally sound green building in conformance with the silver certification level according to LEED rating system. In failing to comply with this contractual requirement, developer will suffer damages in an amount of $635,000. There was a tax credit that they couldn't get because they didn't have LEED certification. So the way this thing really worked, the argument was the contractor had an affirmative duty to deliver a LEED certified building. Not the design professional, the contractor. That sounds a little odd. It does to me. Does that sound a little odd to some of you? In looking at the contract, that wasn't exactly what it said. What the contract said is, the work consists of the following. Project is designed to comply with a silver certification level according to the LEED rating system as specified in Division 1 Section LEED requirement. Their contract said you have to build it in accordance with the design. Remember what I said before about the Spearin Doctrine? If a contractor builds something in accordance with the plans and specifications and it doesn't work, contractor's off the hook. So that was the argument here, that there was a requirement in the contract to build it in accordance with the architect's silver design, but they couldn't get the silver certification, and they were trying to make that the contractor's fault. And if you build it, and there was no argument that they failed to do anything with respect to the plans and specifications. They satisfied everything with respect to the plans and specs. They built it right. The owner just couldn't get that LEED certification.
But what about the lead points that are tied to the contractor's work on the site?
In this particular case, there was no evidence of that. What they focused on was that particular provision. That the contractor did all those things that he was supposed to, and it was not a deficiency in the contractor's work that resulted in a failure to get it and a loss of the tax credit. They were trying to hang their hat on construction language. And again, for those of you that negotiate contracts, and I know this is near and dear to the hearts of many, man, you got to be careful what you say and what you promise you are going to deliver, because that's the thing.